What about Ginni Thomas? That's one of the questions the country has a right to ask after the Chief Justice of the United States, John Roberts, issued a public report today on the Supreme Court's investigation of the leak of the draft opinion that overturned Roe versus Wade last year. In his cover statement about the report, the Chief Justice said the team has to date been unable to identify a person responsible for by a preponderance of the evidence. No one questioned Ginni Thomas. No one questioned any of the spouses of any of the Supreme Court justices. No one questioned the justices themselves in this investigation of the Supreme Court. Samuel Alito, the author of the opinion, and his wife were credibly accused last year of having a private dinner in their home with a wealthy anti-abortion activist couple who got advance word during that dinner of a previous Supreme Court decision. But even though Samuel Alito and his wife have been publicly identified as potential leaks of a previous Supreme Court opinion, they were not questioned in this investigation. The Chief Justice assigned the investigation to the Marshal of the Supreme Court and her staff, none of whom have ever had to conduct an investigation at the Supreme Court before. The Marshal of the Supreme Court, Gail Curley, has the following duties: overseeing the operations of the Supreme Court building, including space management, maintenance and cleaning, renovation, property and supplies, procurement and contracting, telecommunications, parking, managing the motor pool, and coordinating most events at the court, and manages the courtroom, including seating, security, recording proceedings, and keeping time of oral counsel. Investigating leaks at the Supreme Court is not one of the jobs of the Marshal of the Supreme Court. But that's who John Roberts decided should do this investigation. It was John Roberts' personal decision at the outset to assign this investigation to people who had no competence or experience to do it. The Marshal's report says the investigators, quote, conducted 126 formal interviews of 97 employees, all of whom denied disclosing the opinion. Despite these efforts, investigators have been unable to determine at this time, using a preponderance of the evidence standard, the identity of the person who disclosed the draft majority opinion in Dobbs versus Jackson Women's Health Organization, or how the draft opinion was provided to Politico. 97 employees were interviewed. Quote, the investigators determined that 80 personnel received or had access to electronic copies of the draft opinion. 34 personnel confirmed they printed out copies of the draft opinion, and 4 were unsure. Many printed out more than one copy. The investigators informed all witnesses that they had a duty to answer questions about their conduct as employees, that disciplinary action, including dismissal, could be undertaken if they refused to answer or failed to answer fully and truthfully. You cannot fire a Supreme Court justice. No matter what the justice might say in an interview like that, if you interviewed a justice, you could never fire the justice. But no justices were interviewed, and that line proves that no justices were interviewed. We must infer from this report that no Supreme Court justice and no spouse of a Supreme Court justice was interviewed, because the report does not specifically say that, so we have to infer that. But the report never even hints at the possibility that any Supreme Court justice or spouse was interviewed. At the conclusion of the initial interviews, each employee was asked to sign an affidavit under penalty of perjury affirming that he or she did not disclose the Dobbs draft opinion to any person not employed by the Supreme Court. Each of these employees signed a sworn affidavit. A few of those interviewed admitted to telling their spouses about the draft opinion or vote count, so they annotated their affidavits to that effect. The interviews provided very few leads concerning who may have publicly disclosed the document. The report says that the investigators studied, quote, any connections between employees and reporters, and the report says this. Investigators also carefully evaluated whether personnel may have had reason to disclose the court's draft decision for strategic reasons. And the report found nothing to indicate there was any strategic reason for the leak. And despite a Supreme Court investigation by the Marshal of the Supreme Court that found no strategic reason for the leak, the Chief Justice of the United States declared in writing that the leak was a protest of the decision. The second line of the Chief Justice's cover statement releasing the report says the leak was no mere misguided attempt at protest. It was a grave assault on the judicial process. So there is Chief Justice John Roberts leaping far beyond the evidentiary findings of his investigator's own report and claiming that there was indeed a strategic reason for this leak, and the strategic reason for the leak was a misguided attempt at protest of the decision. The leak was a protest of the decision, according to John Roberts. And that is an outrageous stretch beyond the evidence by Chief Justice John Roberts, accusing the opponents of the decision as having leaked the decision. Now, there was plenty of analysis at the time of which side could strategically profit by the leak of the decision, and most analysts agreed that the leak of the decision strategically helped the author of the decision, Samuel Alito, to maintain his majority vote, to lock in place the majority vote for repealing Roe versus Wade. And it did lock the court in place. When the opinion was officially released, it was virtually identical word for word to the leaked opinion, and not a single vote changed. The Chief Justice of the United States ordered an investigation to find out who leaked the opinion and why. His investigation did not find out who leaked the opinion, but the Chief Justice has decided, all by himself, without any evidence at all, why the opinion was leaked. The Chief Justice of the United States calls it a misguided attempt at protest, and the Chief Justice does not even sign his name to that statement that he wrote today. He simply calls it a statement of the court, but it's impossible that that statement could have been written by anyone other than the Chief Justice, which is patently obvious in the very first line of the statement. In May 2022, this court suffered one of the worst breaches of trust in its history. Would any Chief Justice assign the writing of that statement to any other justice? One of the most important events in the history of the court, according to this statement. What is lost in this statement and in this investigation is what the official release of the actual opinion did in this country. There is no analysis of the 10-year-old girls who have been harmed by the actual official opinion of the Supreme Court. Chief Justice John Roberts and the majority of the Supreme Court have no interest whatsoever in the real price that has to be paid every day in this country now by women and girls who have suffered one of the worst breaches of trust in the history of this country at the hands of the Republican majority on the Supreme Court.